How are discrimination claim settlements negotiated? Imagine facing unfair treatment at work and wondering how your dispute might be resolved without going to court. When a discrimination claim is filed, both sides usually want to settle quickly and quietly. The process begins after the employee files a complaint with agencies like the Equal Employment Opportunity Commission or a state civil rights department. These agencies investigate the claim by collecting evidence from both the employee and employer. Sometimes, they suggest informal talks called mediation or conciliation to help the parties reach an agreement. Next, both sides assess the strength of the evidence and the damages involved. Damages can include lost wages, emotional distress, benefits, or even reinstatement to the job. The employee's lawyer often prepares a demand package that states what they want, like a specific amount of money, policy changes, or job references. This demand is usually higher than what the employee expects to settle for, giving room to negotiate. The employer then reviews this demand, considering the costs of going to trial, the risk of losing, and their resources. Most employers prefer to settle because it saves time and money and avoids bad publicity. Negotiations then begin, with both sides making concessions. The employee might lower their monetary demands or agree to non-monetary solutions like training or policy changes. Timing is key. Settling early can give more leverage before formal charges turn into lawsuits. Once both sides agree on terms, they draft a settlement agreement. This document spells out everything, including confidentiality rules, releasing claims, and any non-disparagement clauses. Both parties sign this agreement, which legally ends the dispute. After signing, the employee usually withdraws the complaint or lawsuit, and the employer fulfills the agreed-upon terms. If either side does not follow through, the other can seek enforcement through legal channels. In labor and employment law, negotiating these settlements requires understanding the protections under civil rights laws that prevent discrimination based on race, sex, age, disability, and other protected traits. Good negotiation balances legal rights, evidence, and practical factors like company size and willingness to litigate. Legal counsel plays a big role in advising employees on fair settlement amounts and strategies to get the best outcome. To make negotiations smoother, it helps to document all discriminatory actions clearly. Considering both monetary and non-monetary remedies can strengthen your position. Acting quickly after a claim is filed can prevent costs from piling up. Using mediation or conciliation services offered by agencies like the Equal Employment Opportunity Commission can also make settlement easier. Structuring the settlement to account for tax and benefit issues is another smart move. Overall, negotiating a discrimination claim settlement is about finding a fair solution that respects your rights while helping the employer resolve the issue efficiently.